Morning, Chair. Posh, can you hear me? Posh here.
Yes, I can hear you. But
Okay, Uche, sengilile.
yes.
Okay. Andimva Uche.
But we can hear you.
Okay, uyandiva yini Chair? Chair, good morning, Chair.
Okay, I'm phone because the mic is not activated.
Yeah, okay.
Morning, honorable members and our guests. How is everybody?
Good morning, Chairperson.
Good morning. How is everybody?
We find you. We find you in yourself.
Okay. I saw the minister around. Today, honorable members, we are, should I say, we are in the second stage of our bills, because we are then to be responded to by the department. And I just want to remind honorable members of what I said initially, that we must have our pens and books in order, because after this, we are going to then be engaged in what is called a deliberations. But we have then requested that we then be given today is going to be employment equity, because it won't be fair to us and to the department if we get the briefings both in one day, because they've got quite intense and critical issues that the department is to respond to. So it will then be important that we then focus. Today we'll be focusing on employment equity. It's going to be quite a challenging year for us, because there is another bill that is on a standby. But I think our focus should be on this one, on these two for now. Having said that, I will then request the committee section to take us through the roll call, and then the DG will say who is here, and will then allow the minister for 3 or 5 minutes to just have an overview, and then we will then allow whoever is delegated to make the presentation to us. Mr. Sakaza, can you please take us through? You are muted. Can you please unmute yourself?
Thank you, Chair. Can you hear me now, Chair?
We can hear you.
Okay. Thank you very much. Morning to the members of the committee and the department. We have on our roll call, Chair, Honorable Kado, Honorable Ngabane, Honorable Chair, Honorable Begrim, Honorable Mkonto, and we have also Honorable Mdabe. We have Honorable I'm just looking at them. And we received an apology from Honorable Begrim. I have not received any other apology, Chair. From the staff, we've got Zolani, myself, we've got Poshia, we've got Olelwa, we've got Tebuho. That's all I have, Chair. Thank you very much, Chair.
In your own call, you said we have got Honorable Bagram, and again you said we've got A.
No. I'm sorry, Chair. I said Honorable Michael Kado is in, but Honorable Bagram did put an apology, Chair. Sorry for that, Chair.
Thank you. Can we get a DG? But before the DG, I see the minister's hand is up.
Oh, yes. The minister is here, Chair. Sorry.
Maybe the DG will deal with the issue of my apology. Thank you.
Okay. All right. Lower your hand then, Minister. DG?
Thank you, Honorable Chairperson and the honorable members. Good morning, Minister DM, my colleagues. Chairperson, as the Minister has indicated, we have him. He will be doing the opening and then request to be excused. And we have the Deputy Minister. We have Mr. Seafield, DDG Labour Market Policy. He is with Mr. Temikosim Kalipi. And then we have the support staff from the ministry, Mr. Mweli and Mr. Kangala, and the support staff from my office, Matapelo. And we have our communication guy, Mr. Musa Zondi. Those are the people that we have, Chair. Thanks so much.
DG, thank you, DG. Do we have any people who are coming from outside who may be part of our meeting? Can they please identify themselves?
Sure thing.
Who is that one? Do we have any guest, Mr. Sakas?
Chair, I don't know of anyone who's outside, Chair. They will have to identify themselves.
Chair, I forgot Mr. Wababa.
Okay.
Mr. Tando Wababa is with us. Thanks.
Is this Musa Z? Who is Musa Z?
Musa Zondi from the department.
Musa Zondi. Oh, okay. And Anneli Williams? Who's Anneli?
Good morning.
Anneli?
I'm a journalist from Network 24. Journalist.
But I've been asking who is coming from outside our committee and the department. Is it the first time that you come in front of the committee? In future, when you attend our committee, please identify yourself.
Sorry, we are journalists. We usually attend parliamentary committees. Sorry about that.
No, I know you are a journalist, as you have said, but journalists are not excused from introducing themselves. Please. Who is Pemi Sexby? Pam? Who's Pam?
Who are you?
Hello,
Pam?
I represent who I write for Legal Brief, due to law Legal Brief, but I'm a freelance journalist. Sorry, I wasn't aware that we needed to introduce ourselves. Good morning, everybody.
Good morning. For the benefit of all of you, if it was there's no difference between you being in a meeting if it was going to be a physical meeting where we allow everybody to introduce himself or herself. Yeah, no, thank you very much. No, you are allowed to be in the meeting, but we must know who is here. Thank you very much. Minister, any overview before you leave?
No, Chair, I must just indicate that I will leave after an hour. Thank you very much, Honorable Chair and the members of the committee, the Deputy Minister, the DG, and the officials, the media, and ladies and gentlemen. On a lighter note, Chairperson and honorable members, there's something running in the social media, and I quote, I'm not corrupt. I only took 86 million, unquote. She makes strong confession. Okay, just on a lighter note, but it's there running around. Okay, sorry for that. Chair, I must say that, and I said yesterday to Scopa, it bears repeating that these engagements where Parliament holds the executive, the ministers and officials to account are a central pillar of our democracy. As such, we take them very seriously. As per the custom, the officials will provide detailed presentations with all the facts and the figures. I will simply attempt an overview and to try to convey the strategic and rationale for the department, that strategic direction and the rationale. The Employment Equity Amendment Bill, the responses, the objective of the Employment Equity Bill in line with the Constitution included promoting equal opportunity and fair treatment in employment through the elimination of unfair discrimination and implementing affirmative action measures to address or to redress the disadvantages in employment experienced by the designated groups in order to ensure their equitable representation in all occupational levels in the workplace. So the major changes, Chair, to the EEA include section 15A subsection 3 to read as, and let me quote, the minister may, after consulting the relevant sectors with the advice of the Commission for Employment Equity for the purposes of ensuring the equitable representation of suitable qualified people from designated groups at all occupational levels in the workplace, by notice in the Gazette, set numerical targets for any national economic sector identified in terms of subsection 1. This consultation, and unquote there, this consultation or consultations with sectors and stakeholders have been underway since 2019. To be clear, strict quotas are not envisaged, but a far more flexible model of sectoral targets. The bill promulgates the Section 53 of the Employment Equity Act, which has the effect of excluding companies that do not comply with the EEA targets and goals from doing business with the state. This was not done in 1998 to give employers time to adjust. After 20 years, and given the glacial pace of change in regard to the employment equity, the time had come to take action. I need also to flag that one of the effects of the amendment bill is to reduce the regulatory administrative burden of submission of employment equity reports by small employers. That is, companies that employ up to 49 employees. In order for small employers to obtain an EEA certificate of compliance, they need only to comply with Chapter 2 of the EEA on unfair discrimination and comply with the National Minimum Wage Act. So in their presentation, the officials will provide details of the responses to the amendment bill and indicate where the department has moved to address the concerns raised. But we must be clear that sometimes voluntarism has been very dangerous, and people deliberately neglect all those issues. That's why we've been forced to come up with this. Thank you very much, Chairperson. Thank you, Chairperson.
Thank you, Honorable Minister. Thank you, Honorable Minister. Thank you, Honorable Minister, for that brief overview. We will then now be indicated by the DG, who is then going to make the presentation to us. I also I forgot to say this. By 1:45, I will request to be excused. I hope will be done by that time, because we've got another meeting with the Chair of Chairs, Honorable Frolick. Thank you very much, honorable members. DG?
Thank you, Chair. I'm going to ask Mr. Thembinkosi Mkhaliphi to do the presentation on our behalf. Thanks, Chairperson.
Over to you, Mr. Mkhaliphi.
Matebo, can we flight the presentation?
Sicela ukukubona ke, Mr. Mkhaliphi.
I have not changed, Chair. I'm still the same. And
Chair, I'm making Matapelo a host so that she can.
Okay.
Wasikukhangeleka mncinane ngoku Rhatebe. Uthini? Xolo Chair.
Sorry, Chairperson. I'm checking Umatapelo. I'm not getting him. I hear. Sorry, I think the technology chair.
We have, Zolani, can you allow me to? We
Yes,
are, whilst we are still waiting for the issues of the technology, I'm of the understanding that we were circulated this as members. Can we
Yes.
look into our documents whilst the staff is sorting out the issue of technology?
Okay, Chair. I don't see Umatapelo Ngenile, Chair. That's why I don't get her.
Thank you, Chair. Then I'll do as
Please,
you
Zolani.
suggest.
Oh yeah, she is.
Uteni, why there's no order in this meeting today, Mr. Sakas? You just speak when you want to speak. What is happening? Can I be told there's something that I'm missing? I'm somebody who likes order. And there will then be order. And you must mute yourself, Mr. Sakas. Over to you, Mr. Mkalipi.
Thank you, Chair. My presentation, the presentation from the department covers constitutional mandate. The minister dealt briefly on this. We are also going to cover the objective of the law as it stands. And we'll deal with the status of how companies has performed over the last 3 years in terms of implementing the law. We'll give you statistics in terms of that so that members can have some sense of why are we introducing the amendment that we're introducing, precisely because of the slow pace of change in the labor market. We'll deal with case law members. Remember, some of the people that made public comments on this issue raise legal issues that we need to respond to. We'll unpack the issue about socio-economic impact assessment, this issue that was a big issue about it, unpack it and explain what is it and how does it affect what we do. And then we will deal with the parliamentary public hearing, the matters that came out in the public hearings in terms of the bill. And then we'll take the members through on the areas that on our response on what we agree in terms of some of the areas that have been raised. And then we'll take members through the consultation process that we've already that has already taken place with the different sectors of the economy. Now, members, as members would know, in terms of the Constitution of the Republic of South Africa, Chapter 2 of the Constitution, Section 9, guarantees that everyone is equal before the law, and there's a right to equal protection and benefit of the law. And the Section 9.2 goes further and indicates that equality includes the full and equal employment of all rights and freedoms. To promote the achievement of equality, legislative and other measures designed to protect advancement of persons and categories of persons disadvantaged by unfair discrimination may be taken. This is where employment equity is placed. The Constitution says Parliament and the executive must introduce laws that deal with the consequences of apartheid, and that's what employment equity is trying to do. Section 9.3 of the Constitution indicate that the state may not unfairly discriminate directly or indirectly against anyone on one or more grounds, including race, gender, pregnancy, and all of the other grounds. And in doing that, in Section 9.4, the Constitution indicates that no person may be unfairly discriminated directly or indirectly against anyone on more of the grounds that are listed. But it goes on and say national legislation must be enacted to prevent or prohibit unfair discrimination. And Section 9.5 indicates that discrimination is one or more of the ground insisted in Section 3P. Unfair is unfair unless it is established that the discrimination is fair. Therefore, the Constitution does not outlaw discrimination. The Constitution allows that there will be discrimination in the country as long as that discrimination is fair. If that discrimination is intended to address the imbalances of the past, that discrimination become fair. Therefore, the Constitution does not say altogether there should never be a discrimination in any country. The Constitution says if it's an unfair discrimination, then the law will come in on that. Now, to achieve equity in the workplace and promote equal opportunity and fair treatment in employment through elimination of unfair discrimination, that's what the Constitution asks us to do, and that's what employment equity is intended to do. And in implementing affirmative action, measures to redress disadvantage in employment expressed by designated groupings in order to ensure their equitable representation in all occupational levels. That's what employment equity is trying to do. Now, unfortunately, members, the slides are not in, but you've got the slides. We've given you a report that shows how has been the performance of the labor market between 2018 and 2020. Now, if you look in terms of the EAP, Economically Active Population, which is published by State South Africa, African male make out 42.8, about 43% of the EAP. African females make up 36% of that, and coloreds male make 5.3, and Indians males make 1.7, and the colored female make 4.4 of the EAP. But if you look at what has been the representativity of Africans, coloreds, and African female and males, in 2018, Africans at top management constituted only 10% of all the companies that have reported. In 2019, they constituted 9.9%. It went down in 2019. In 2020, it went up to 20.1%. Therefore, from 2018 to 2020, it went up by 0.1%, which is very, very minimal progress. If you look at African female, the same applies here. African female make up about 36% of the EAP. And at top management 2018, they were at 5.1%. And 2019, they were 5.4%. And at 2020, at 5.7%. Now, this picture applies also to a colored male who constitute, instead of being 5.2%, 3.4 2018 and 3.5 in 2020, which is a difference of 0.1% between those. The same applies to colored female. They are worse than colored male in that they made up 4.8 of the EAP, 2% in 2019, and 2.2% in 2020. Now, that's the indication of the slow pace of transformation in the labor market at top management. The same applies to senior management. At senior management, you find the same situation, the same numbers. Africans will be at around about 14% and 15% in 2020. African females will be 8.8%, 8.6% in 2018, and 9.5% in 2020. The same applies to colored females. The same applies to colored males at senior management. The same picture applies at professionally qualified. Although the numbers, the percentage are going up a little bit at professionally qualified, because African males in 2018 were about 20.9, and in 2020, 22.7%. And African females were about 18.3%, and in 2020, about 24%. At least there is some movement taking place, although at a small rate, even at professionally qualified, but compared to senior and top management, you can see that there is movement. And these are the people that you would expect they will be given opportunity to move to senior management from professionally qualified. The same will apply to colored, as I've said. African female as professionally qualified make up about 19.8% in 2018 and 24% in 2020. As I've said, colored females have done a little better at this level because their EAP, which is at about 4.4%, they are almost around 4.8, 4.9, and 4.8, which is what the EAP is. The real challenge is with African females and the African males in terms of this. Also, colored males haven't done badly in terms of the movement at professionally qualified. They are far closer to their EAP than at senior and top management, which is very good in terms of the movement that's in place. But the major problem, as I've said, is between African males and African females at this level. As skill technical, here, as expected, there's a big move. You see African males at 32% in 2018 and 32% in 2020 also. There's numbers there, people at least, although they are still not below their EAP. If you look at colored males are surpassing their EAP at this level. The same would apply to colored females. They are surpassing their EAP, but African females are below their EAP, but the numbers are far better than compared to top and senior. As you go down the levels, more numbers are coming in on Africans, coloreds, and Indian. As you go up the levels, lesser and lesser are accommodated. The other area which is very problematic is the accommodation of people with disability in the labor market. 2018, you had 1% of workforce in the labor market made out of people with disability. 2019, that went up by 0.1% to 1.1%. In 2020, it went up by another 2% to make 1.3%. And those are the issues that we, in terms of the setting of the target, we hope that we'll be able to redress and deal with and move a transformation forward. Now, in terms of case law, now, members will remember that Solidarity has raised the issue that employment equity is unconstitutional. There are challenges about it. And we wanted to take members through the history about this issue. On July 2018, the South African Human Rights Commission issued a report entitled Achieving Substantive Economic Equality Through Rights-Based Radical Economic Transformation in South Africa. It's called the Equality Report. The report concluded that the definition of designated group in the Employment Equity Act, broadly, the categories of persons who are beneficiaries of affirmative action measures established by the Employment Equity Act is not in compliance with the Constitution. That's what the report said, or international law obligation, and recommended that the Employment Equity Act be amended to target more nuanced groups on the basis of need. Therefore, the Human Rights Commission's report says, well, don't look at race, don't look at gender, look at the need, therefore cover everybody in terms of the need, and taking into account social and economic indicators. And the Employment Equity, the report went further and said the EA and its implementation, as well as design for specific measures, are currently misaligned to the Constitution objective achieving substantive equality. That's what the report says. And then Solidarity relied on this report, on the equality report, to seek an order declaring that they took the department to court, declaring that Section 42 of the Employment Equity Act, read with the definition of the designated group in Section 1 of the Act, is unconstitutional because REC cumulatively, they do not provide for appropriate classification of disabled group other than on the basis of race, gender. Solidarity sought an order confirming the finding of the recommendation made in the quality report insofar as it relates to employment equity. Solidarity submitted that equality report had binding effect because of its factual existence. That's what Solidarity said in court. We went to court on this issue. And in court, we were together with the South African Human Rights. The South African Human Rights Commission indicated clearly that this is just a research report. It's not a report released for implementation. It's a research report by the researchers that were commissioned to do this. And the application that Solidarity brought in the Labour Court was dismissed by the court on the following reasons. The court says no statutory or regulatory provision that rendered the equality report binding on government or any other party. The court says that this report doesn't bind government on anything. And then also the South African Human Rights itself did not intend the report to be binding because the South African Human Rights submitted an affidavit on this issue indicating that this report is just a research that they've done. It does not intend to bind anybody. And the report is a research report intended to contribute to the public discourse and to provide advice and guidance on government. It's intended to open discussion that we are prepared and able to do. And then the court says there were no basis on which the court was empowered to confirm or otherwise enforce the report finding and recommendation for the purpose sought by Solidarity or for any other purpose. So Solidarity has not sought to postpone postpone that part of the application which seek to declare Section 42 of the 8 unconstitutional. They went to the Labour Appeal Court. The Labour Appeal Court also dismissed their case. They went to the Constitutional Court. The Constitutional Court also dismissed the leave to appeal to the Constitutional Court on this case. Now, Solidarity is coming on the same basis, in the same case, to Parliament to argue that employment equity is unconstitutional, and they want to argue that the report released by South African Human Rights supports this. Now, we're raising this issue so that members can see that this case has gone its own length in terms of judicial process in the country, starting from the Labour Court until the Constitutional Court, and all courts of the land have pronounced on this issue. Therefore, we don't think that there's any reason for members to even consider the submission made by Solidarity on the issues of constitutionality of employment equity. Now, on the socio-economic impact assessment, many members of public who commented are raising an issue that there was no socio-economic impact on this. The socio-economic impact was not published, and we wanted to try and indicate what has happened in this. The socio-economic impact that must be done on any government proposed bill or amendment or policy is an internal government process. It's a decision of government. The cabinet took this decision in order to make sure that when bills or policies are proposed, that cabinet is assured on the consequences and the unintended consequences of whatever bill and policies that are put on. And this is administered by the Department of Planning, Monitoring and Evaluation. It's not monitored and implemented by different departments. The department, before the bill can be tabled in the DG cluster and cabinet, should prove that the bill to be published for public comment or for tabling in Parliament, that the bill has gone through socio-economic impact assessment. Therefore, this bill went through that process. The department, the DPM, the Department of Planning and Monitoring, has published a template of how impact assessment should be done. And this bill went through that process of the template. And the certification that is issued by the department itself, and that certification is tabled at the DG cluster at cabinet. And there's no legal requirement to publish the report, but the report is published on our website and is available to any member of the public that want to see the report. If they can't find it in the website, they can easily contact the department and it will be emailed to them. as members will confirm that the report has also been submitted to members of Parliament for them to look at what the report indicates. Now, in relation to this bill, we conducted the economic impacts assessment before the bill was published for public comment in September 2018. We again did a socio-economic impacts assessment in 2019 after the bill was commenced and the bill was going to cabinet for it to be processed for Parliament. And the intention of this CSR, the assessment, is to make sure, as I've said, that we minimize unintended consequences from policy initiative or regulation that we introduce. And it assists policymakers to anticipate implementation risk and encourage measures to mitigate them. Now, to do this assessment, departments need to answer 4 questions. 1, what is the impact of the bill that we're introducing on social cohesion, safety, food, finance, energy? What is the impact of the bill on economic inclusion? What is the impact of the bill of the policy on economic growth? And what is the impact of the bill of the policy on environmental sustainability? Those are the 4 areas that when we do an assessment on economic assessment of any policy that we introduce, that we need to answer. And what we did answer those exactly. As we've indicated, this bill was proposed, an amendment were discussed by the commission, which advised the minister in 2017. And the commission consists of business and labor and community. The amendment bill was then tabled at NETLEC, and there was a long discussion in 2017 at NETLEC on this bill, and there were agreements at NETLEC, and areas that you agree on and areas that you did not agree on. And the report then, a NETLEC report was developed, and the NETLEC report is available. Members can have access to that report if they need be. And the bill was published for public comments in 2018 for 60 days, and then public hearings were held in 9 provinces on the bill. We even went further as the department had consultation with the Department of Treasury, DTI, and the CCMA in order to make sure that the linkage that we want to make are up and running, and the link between our system. And we also linking up with our system on the national minimum wage to ensure that we are able to implement the bill when it's passed by Parliament, if it's passed. And we've already started, as the minister indicated, started with consultation with different sectors. And as you will see in slide 31 to 33, where we list the sectors that we've already consulted around the setting of target. Now, I'm not talking about consultation on the bill. I'm talking already on consultation because we've taken a decision that says we need to start now with the consultation process instead of waiting for Parliament to finish and the President promulgate the bill. Because if we do that, we are going to miss a lot of time. Because we are of the view that it's easier if Parliament does not pass this bill. Therefore, we're not losing anything if we've already consulted. We'll just not implement the result of that consultation. Or if the President does not promulgate it, we're not going to. But if we're going to wait until the bill is passed or President promulgate the bill, then start consultation, it's going to take a longer time for the targets and the provision of the bill to be effective. Therefore, we've already started that process. Now, members, these are the following areas that we're responding to. Socio-economic impact assessment, we've already talked about that one. We're responding on the definition of designated employers. There were comments made about the definition on this. We're responding on Section 15 of the Employment Equity and Section 15A Amendment Bill. Sector-specific targets versus quota. We're explaining our understanding about this. We also giving members the steepest of the regulation in terms of reasonable progress and justifiable reasons. Because you had the comment where Business South Africa was saying that we need to assess reasonable progress, not a target. And then we putting that against justifiable reasons in terms of not meeting the target. We'll explain all of those issues. We're talking about corruption versus compliance, because there were issues that were raised in the public hearing that talk to saying that the target setting regime that you're introducing will increase corruption by our inspectors. We'll deal with that issue. We'll talk about compliance certificate versus procurement law. As you members will remember, CSR, one of the public comments raised the issue of unconstitutionality of this provision in terms of Section 27, in terms of procurement, saying that this is a procurement issue, therefore it should be dealt by procurement legislation. We're responding on that. The processing of issuing of compliance certificate, we're explaining, unpacking that so that members can understand and know which way you're going. Although some of these things are not in the law, they will be in the regulations. I'm sure if members want to have sight of the regulation can also can be taken through on the regulation themselves. As we've indicated, the assessment was first done in 2018, again in 2019, when we presented the bill for cabinet and for the bill to be put in parliament. Therefore, we think that we've done everything that we needed to do in terms of the socio-economic impact assessment. The amendment bill is intended, as the minister indicated, to reduce regulatory burden for small business. And now this is one of the areas. There was a member who asked this issue on the public hearings. Why are we amending the definition of designated employers? There's a big push by all government departments. This is what the CSR, the economic assessment that we've done, that shows that we need to reduce the burden for small business. And this proposal that the minister talked about, where we say, if you employ less than 50 employees, you don't have to report. The report requirement should not apply to you. And the only area that you should be worried about, if you want a certificate, because small business do also tender, they tender for catering and other work. And if then you want a certificate, you answer two questions. One, has there been an unfair decision on unfair discrimination decided by the CCMA, by the Labour Court, any institution against you in the last 12 months? If you answer in that case, no, there's been no case. Remember, I talk about the linkages between the CCMA and our system. And the CCMA will be able to verify that when you say no, there's no case of unfair discrimination against our company. The next question that's going to be asked is, do you comply with the National Minimum Wage Act? You pay national minimum wage. If you answer yes, then you get your certificate. Therefore, you must answer no and yes. If you answer yes in both of them, then it means that you've got a case against you on discrimination. You are not going to get, even if you're a small business, a certificate. Therefore, we can't allow any company to discriminate unfairly against anybody. And that's why those two questions for small business are put on the table for them to answer. On Section 15, Section 15 states that affirmative action measures are measures designed to ensure that suitable qualified people from designated groups have equal employment opportunities and are equitably represented in all occupational levels in the workplace. And Section 15.2 states that affirmative action measures implemented by designated employer must include measures to identify and eliminate employment barrier, including unfair discrimination, which effectively affect people from designated grouping. Measures designed to further diversify the workforce in the workplace based on equality, dignity and respect for all people, making reasonable accommodation for people from designated grouping. This is what the law already states as it is. There are no changes in this section. It's what the law states. Next slide, please. Now, Section 15 of the Act ensure that equitable representation of justifiable qualified people from designated grouping in all occupational level in the workplace, and retain and develop people from designated group, and to implement appropriate training measures, including measures in terms of the Act of Parliament providing for skills development. And Section 5.3 stated that the measures referred in subsection 2D include preferential treatment and numerical goals, but exclude quotas. Now, that's what the law says. It says it needs to exclude it. We need not set up quotas in terms of the law. Now, 15.4 states indicate that nothing in this section requires the designated employer to take any decision concerning employment policy practice that would establish an absolute barrier to the prospective or continued employment or advancement of people who are not from designated grouping. There's nowhere in the law that says that white males should not be appointed, for example. But the law says that you need to put up arrangement to ensure that you give equal opportunity to every employee. Next slide, please. Section 15A, capital A, which is a new provision that we put in it. This is a section that gives the minister the power to introduce targets. It indicates clearly that the minister may, by notice in the government gazette, as the minister has indicated, identify national economic sectors for purpose of this act, and having regard to any relevant code that are published by State South Africa. And then the minister may prescribe criteria that must be taken into account in identified sectors. And then it goes further and says the minister may, after consulting NETLEC. Now, this issue, there was a big comment on this because the bill that is in front of members in parliament has left out the issue of consulting the relevant sector. And we are proposing in terms of this that we need to, the members of parliament, if they agree, need to amend the bill as it stands and add in that section in 50.A3, 50 capital A3, add the red part that is written there, the relevant sector, and with the advice of the commission. And the reason we're doing that, because that's what was agreed at NETLEC. And it's important that we affect all the agreements at NETLEC. It was by mistake left out of the drafting when we drafted it. And therefore we agreed that that change needs to be made in the bill so that it reflects the NETLEC agreement. But the whole clause as it is, it's in the bill except the red or orange part that is in the one that reads the relevant sector and with the advice of the Commission on Employment Equity for the purpose of ensuring that equitable representation. And this is the section that says we must consult, as we've indicated, members, although it's not in the bill, because we accept that that was an agreement agreed at NETLEC, we've already started the process of consultation in this, as slide 33 will show. Next slide, please. Now, to give effect to section 15.3A in the bill and the NETLEC agreement in relation to consultation with sector stakeholder for setting sector-specific targets, we've started sector target, as we indicated, with National Treasury, with DTI, with Department of Higher Education, and in our department with the employment section to include the linkage between the minimum wage exemption processes and the exemption processes that we are going to work with in terms of this. Now, by March 2021, we've already consulted with 16 sectors of the economy. Those sectors ranging from the financial sector, the mining sector, the retail, and many, many sectors that we've already consulted, and we're continuing with the consultation. And one of the big sectors that's still outstanding that we need still to finish, and in terms of our planning, we're hoping that we'll finish it by June. We might have be a little bit late, finish it by July, but we'll finish between manufacturing and public administration. Manufacturing is a big sector that we're also consulting with, and other sectors. Now, that's the consultation is we putting a proposal to them on what the target for that sector should be. And members, our approach on target setting is that the target is going to be a 5 or 3 years target for the sector. If we set up a target that says in the next 5 years, representation at top management should be 50% for African female, 50% African male, whatever it is, then what will happen is that each company will have to decide how they were going to affect on an annual basis that target until 5 years. Therefore, we're setting sector targets, but companies will set their own targets against the sector target. Next slide, please. And the notice that will be issued in terms of section 15.4a, 15a4 may set different targets for different groupings. We might set a different target for Africans at top management, Africans and female. We might not set even targets for coloreds and Indian and colored female at the lower level where they've met their EAP. Now, one of the other issues, this target setting will be published by the minister in the form of a regulation, and the bill allow that they should be public for comment for 30 days, even after consultation. Now, there's been an issue about the 30 days, whether is it long enough. We believe that the proposal made by somebody that we should increase the days is not reasonable, because as we've said, we're consulting the sector. Then after consultation, we even go out and publish it for public comment. And the 30 days, we believe that is sufficient for public comment for us to be able to move forward. Next slide, please. Now, there's this issue, whether are we setting quotas? And our view is that we're not setting quotas. Quotas has got a mandatory outcome. A quota says you must be 50%, irrespective of what happened. That's what we need to put in. In terms of the target, the targets are aspirational goal. Quotas are rigid, must be achieved at all costs. Targets are flexible, but attempt must be made to achieve the goals where reasonable practicability. Penalties instituted for missed outcome, no consideration for justifiable reason in quotas. We've got already built in the regulation justifiable reason. Next slide, please. Now, in terms of the justifiable reason that are in the regulation that the minister has published for public comments, that are waiting for this process, already published for public comments. And these regulations, as we indicated, were debated and discussed at NETLE. Now, any employer must comply with the targets that are set for the sector. And if an employer is not able to meet that target, in terms of the section 16, they must have justifiable reason not to do so. Now, in terms of the regulation, the employer would have about a number of 7 justifiable reasons that were agreed. The employer can say, I did not meet my target because there were insufficient recruitment opportunities. Nobody left in this company. Turnover is nil. There's no retirement, there's no dismissal, there's no insufficient promotion is not there. Or a company can say insufficient target individual from the desert group with a relevant qualification. They can say, well, we need African female, but we can't find African female in the labor market that has got the skills and the experience that we need for whatever reason. Or they might say, as a result of a court order, we have not complied with the target. Or they might say, well, we intended to comply with the target, but because of transfer of business, there's been a transfer, there's been a movement, our business was transferred, or because we bought another business and then it then affected our ability to comply with the target. Or there's been measures that have been bought by somebody else who would even raise the impact on business and economy circumstances in terms of this. Now, in light of the above flexibility, there's no need to tamper with the target that we are setting, because if you've got justifiable reasons for not complying, as long as those reasons are justifiable, now how will they be justifiable? When you submit your report on an annual basis, the system is going to analyze whether you've complied with your own target that you set for yourself against the sector target. And if you have not complied, the system is going to tell you, you have not complied with your target. Do you have justifiable reason? If you say yes, then the system will give you this justifiable reason, and then you select it. You don't have to write anything. You select those that are applicable to you. And then what will happen in terms of this is that if the inspector find out and rule that your justifiable reason is not justifiable after all, then the certificate will be withdrawn. Now, Section 53.6 indicates that the minister may issue a certificate in terms of this. And the employer if the employer has complied with the target set by the employer themselves against the sector target. And in respect of any target with the employer has not complied with, the employer must have reasonable justification for not complying. If they don't have the reasonable justification, then they don't get certificate. The employer must submit a report in terms of Section 21 of the Act, the present provision. There has been no finding. If there's no finding at the CCMA, as we indicated, or the court on unfair discrimination, you get your certificate. If the CCMA has not issued an award that says you're not complying with the minimum wage, you get your certificate. Next slide, please. Now, one of the issues that are being raised here is that this is going to delay the process and it's going to take longer for companies to get a certificate. Now, members, we need to explain this clearly. Presently, companies submit their report into our system. And if a company submitted a report and press submit, they can get a letter immediately from our system that says your report has been captured, submitted. Just like members pay their tax, I hope all of us pay tax here. When you submit your tax clearance to SARS, you get immediately an email from SARS that says your submission has been assessed. This is the amount of money that you get, or this is what you owe SARS if you're unlucky. Now, that's how the present system works. It's not something that we're thinking about. It has been working like this for the last 10 years. You submit your report, you get the confirmation of a report, you print it yourself immediately if you want a confirmation on that. Therefore, all of this certification, there's no human involved in it. There's no inspector that will ask for a brown envelope to give you a certificate. You submit your report, you print your own certificate. The system will give you automatically your own certificate if your report is up to standard. And it's easy, it's emailed, it's printed, you do it yourself as an employer. Our system, as we indicated, will be linked with the CCMA and the exemption system. Therefore, you can't say, I don't have a case when you've got a case because you'll be linked with the CCMA. You can't say, I don't pay minimum wage, I've got an exemption from the national minimum wage exemption system because it's going to be linked, it will indicate that. There will be no manual certificate. Therefore, there's no issue about inspectors issuing a certificate. What inspectors will do, inspectors will go to the company that has got the certificate and say, well, you receive a certificate when you have not complied with your targets. You indicated that these are the reasons that you did not. And the inspectors will have to analyze those justifiable reasons. The inspector might decide and say, no, we do not believe that the reasons that you've indicated are justifiable because your competitor next door who's doing exactly the same thing that you're doing has been able to meet their target, operating under the same economic circumstances that you operate in. Therefore, we don't believe that the justifiable reason that you've cited is justifiable. We're withdrawing the certificate for you. Therefore, the certificate, you get the certificate, but if at a later stage it is found out that the justifiable reason that you did is not applicable to you, that certificate will be withdrawn. It's not issued by the inspector, but the inspector will analyze that. As we've indicated, small business will be issued a certificate after answering those questions that the ministers talk about. Next slide, please. Now, in this slide, we're answering the issue that was raised by the clients that commented on the constitutionality of the legislation and saying that this can only be done by procurement law, is unconstitutional in terms of Section 27. Now, our view is this: if certificates are unconstitutional, why is it permissible for SARS Because in this country, if you don't have a tax compliance, you can't procure with government. Why is it that permissible? In terms of the BE Act, if you don't meet your BE requirement, you can't procure with government. Now, we do not believe that Section 27 of the Constitution is infringed in introducing this. And this was confirmed by State Law Advisor. It was confirmed by our legal advisor that was procured advisors through the NETLEC process, both Helton Chidle and Paul Pretorius, Paul Benjamin work on this bill. Therefore, we're confident that there's no issues around constitutionality. Now, if it's unconstitutional in terms of Section 27 for this provision to be in the Employment Act, it will be unconstitutional in the common tax law. It will be unconstitutional in BE. Therefore, it will mean that all of these provision can only be done through procurement law, and we do not believe that's the case. And if that was the case, in fact, Section 53 of the Act is not a new provision. It's already in the Act. If anybody want to challenge it, has never been challenged in court on this. Although the Act, the section was not promulgated for the last, precisely because of what the minister indicated, wanted to give first the chance for business to see whether they are able to self-manage themselves and ensure that promotion equity takes place. Secondly, is that we wanted to, there were no tools when the Act was promulgated then to assess what is compliance. Is compliance reporting only? Is compliance also ensuring that transformation takes place? Now that we've introduced targets, the targets are the mechanism to assist us to ensure that we've got enough tools to ensure that if you don't meet your target and you don't report, then you're not going to be able to transact with government. And the issue therefore raised, the concern raised by SAFCAS, next slide please, about the issue of the Constitution, we think they are misplaced, but well, anybody has got the right to challenge any law and go to the Constitutional Court, just like Solidarity have done. If that takes place, and we're not going to shy away to go and protect and defend the legislation, just like we did in many other cases that were there out in the Constitutional Court. And the issue about corruption, that the certificate that we put in is going to make it possible for inspectors to involve in corruption. We all concede that we live in an environment where corruption and bribery is rife in our country, but we cannot stop law enforcement or lawmaking only based on fear of corruption and bribery. We must deal with corruption with both parties. Remember, if there's a corrupt inspector, there's a corrupt company, both of them must be dealt with and be taken to on book on this. Therefore, we can't be put on freeze because we fear that the policy that we're introducing might open up corrupt practices in terms of this. We believe that corruption must be fought by all of us. We must continue to enforce the law. Both labor laws, criminal laws must be enforced to ensure compliance and peace, stability in the labor market. If we're not going to enforce our laws because we believe on these issues, we don't think that is right. Considering the submission then that were made by oral presentation, for us, we want to propose some of the changes that the members should consider. Section 15.3a include consultation relevant sectors. We've already indicated that we'd want to include that the targets must be set after consulting relevant sectors. Section 37, where we putting there's any other person that is or for who works for inspector, we agree that that area must be taken out. It must be also only the inspector that is able to implement Section 37 and implement this law, no other person outside the inspector. Now, Section 53 talks 3 years, it should read 12 months because the report is on an annual basis, and the arbitration award, if you submit your report, you need to indicate whether you have a judgment at the CCMA for the last 12 months, not the last 3 years. And that's another change that we want to make in the law to ensure that it captures what was agreed at NEDLAC, because that's what was agreed at NEDLAC with our constituencies. Now, as we've indicated, that these are the sectors that we've already consulted: agriculture, forestry, mining, construction, information and technology, financial services, real estate, property, professional, scientific and technical activities, chartered accountant, transportation, storage, accommodation, food services, public administration, defense. All of those sectors have been consulted in terms of what the targets will be in their areas. In June 1999, the commission started the consultation on these issues, as I've already indicated, to set up the sector-specific, dealing with top management, senior management, professionally qualified and skilled technical. And although, as I've said, that the bill is still in Parliament, we continue with the consultation in order to prepare ourselves for us to be able to move with speed when the bill is passed and the president signs in law, if it is. Next slide, please. And these are the dates and time of the relevant sectors that we've consulted in terms of this. Other sectors that we've consulted, that will continue to consult. As we've indicated, public administration and defense are not yet consulted, but we'll consult all sectors of the economy. Some sectors have come back to us, some we're waiting for a response, written submission, so that we can go in. Remember, members, this is consultation. This is not negotiations. If there's no agreement, we'll in good faith consult in order to reach an agreement. But if there's no agreement, then the minister must make a decision. It's the same as Section 189 of the LRA. Section 189 of the LRA that deals with retrenchment does not require that there must be an agreement between parties, but it requires that parties must consult in good faith. We're doing the same in this section, consult in good faith in terms of setting the targets. But if we're not able to meet each other, in many of these, we are closer to meeting each other. We hope that in all of them we'll meet each other. Where we can't meet each other, then the minister will have to decide. Thank you very much, members.
Thank you very much, Mr. Mkalipi. Thank you very much, Mr. Mkalipi. Honorable members, there are the responses that have been tabled by the department on issues that have been raised. Are there any comments? I see Honorable Kado. Any can I just check if is there going to be any other? It's Honorable Kado, it's Honorable Mkondo, it's Honorable Dana. In that order.
Thank you, Chair, and thank you to the presenter. I've got two questions to kick off with. The first one is around issues of constitutionality. And in the course of your presentation, you referred to Solidarity's court action over the Human Rights Commission's Equality Report to explore issues of constitutionality. But you do this quite narrowly, in effect. What about the Concord tests that were set out in the Van Heerden case in 2004 about remedial measures, which stated that those measures must target the disadvantaged and must promote the achievement of equality? And can you really say that this amendment bill passes those tests? We heard from some of the submissioners during the course of the public hearings that racial targets help only about 15% of Black people, in other words, the most skilled and or politically connected. And we also heard that the Gini coefficient of income inequality has risen pretty significantly from 1994 to the present day, and that the poorest 40% of Black South Africans had roughly the same share of national income in 2015 as they did in 2006, despite stricter targets that were introduced through the 2013 Amendment Bill. So do you have an answer to whether this Amendment Bill is effectively going to address those concerns raised by the submissioners during the public hearings? Then secondly, your distinction between quotas and targets seems to me pretty tenuous. You call these targets aspirational goals underpinned by flexibility, but the bottom line is that an unmet aspirational goal carrying the threat of punishment, whether it's in the form of a withheld certificate of compliance or whatever, is a quota by another name. And the consequences of not meeting these sectoral targets would prevent organizations from transacting with the state. It would mess up their revenue lines. It could result in liquidations of their businesses. It could well lead to job losses. And how do you justify that in the context of economic destruction and decay, partly caused by the pandemic and the lockdown, but also caused because of deeper seated structural issues to do with our economic policy environment? And my question, I suppose, in this regard is, have you actually given any thought to what this bill in its current form is going to do to economic growth and job creation, which must surely be the priority of this ministry as it was reconstituted in 2019? Can you hand on heart say that the Employment Equity Amendment Bill is actually going to do anything for economic growth and job creation in South Africa? Thank you, Chair.
Thank you, honourable members. Can I just try to guide the meeting so that we don't do other things by default? There is nothing wrong in asking clarity. I'll just make an example on just the first member, on asking why pick on this case law, why not this one? That is fine. But then the question on the issues of target, that is bordering into engaging in deliberation. So the members must really, I know it's quite a thin line, but we must just try to get some clarities, because we are still going to, your second question is bordering into deliberations, which you then have, you still have to ask that when we deliberate, put your view on what then you think targets, blah, 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 blah. But the first one is fine. I'm saying it's that question, that why pick on this case law, why not this one? That is okay. So I just want to just caution members to tread a bit carefully. I want to repeat, I know it's a very thin line. Ours now, it's just clarities from the department, so that when we then engage as parties at the time, we will then do that. Honorable Mkhonto.
Thanks, Chair. Greetings to you, Chair, honorable members, the staff, and our guests. Chair, my first question will be, maybe it was just an expectation that as we talk about designated groups, divide them into male and female, I am happy that the disabled, there is a slide that talks about the disabled. I also expected maybe we would have something to explain as to what is the status quo with what we are talking about, employment equity and the levels within the corporate environment. and the issue of the youth. I thought maybe we'll be told as to how are we faring as a country in as far as the youth is doing in the corporate levels. And then, Chair, the second one will be on slide 27 that speak about the insufficient recruitment opportunities as one of the reasonable reasons from employers. I need a clarity, Chair, as to does the department feel that they will be able to, does this don't have loopholes? As we know, the history of our country, you find recruitment advertisements written, people must be fluent. I'm making an example, must be fluent at a certain language. Are such things going to be checked if an employer gives a reason to say, I couldn't comply because of insufficient recruitment opportunities? So are the advertisement for the recruitment itself, are they going to be checked? That's what I'm checking, Chair. There is an abbreviation, Chair, on slide 29, SARC. I don't understand if that can be clarified as what it stands for. And I'm a little bit not comfortable, Chair, with the closing statement that says a consultation doesn't lead to the department to be obliged to agree with the parties. The minister, if there's no agreement reached, then the minister will decide. I feel that statement, it was presented prematurely, as we are still busy with consultations and discussions. So if that is the case, Chair, why are we wasting our time doing consultations, sitting in meetings, and at the end of the day, the minister will never even, if we don't agree, it means we are obliged to agree. So I'm really worried about the closing statement. Thanks, Chair.
Honorable Dana.
Thank you, Chair, and good morning to everyone. Thank you for the presentation. My question, I have one question. It centers around the socioeconomic impact assessment. Mr. Nkalipi said in his presentation that Cabinet needs these reports to be assured on the consequences of amendment bills. Now, I have quite a problem with the socioeconomic impact assessment that is before the committee and before Cabinet for this amendment bill, because there are a few things missing. I, for instance, don't see any comparisons with other countries with similar circumstances and legislation.
Sorry, Honorable Member. Sorry, Honorable
It is a
Member.
question of clarity, Chair. I'm getting to it.
But please go straight to question of clarity. Don't start by deliberating. That's
Okay.
where I think it's fine. It's fine. You can continue.
Thank you, Chair. So I see there is no comparison with other countries with similar circumstances and legislation. There is also no thorough financial impact analysis, and it does not seem that this report conforms to international best practice. I have also looked at other countries' impact assessments. So I'd like to ask Mr. Nkalipi, will Cabinet be able to confidently say that this report as is will assure them of the consequences, both intended and unintended, of this amendment bill? Because I cannot see that it will be able to do that, and that they will be able to say that based on what we have before us. Thank you, Chair.
Honorable members, please, can we ask that? I understand. Can we ask questions, because we are going to have a time to raise some of the issues that we're raising. And well, the department will respond on the issues that are affecting cabinet. But please, I understand our expectations, but we can just get clarities. We'll engage in some of the issues that we want to talk about, to engage the department on, and our views as members, and what is the view of our organizations. Honorable Ngabane.
Thank you so much, Chairperson. Greetings to the honorable members, the department, the Deputy Minister, the Minister in absentia, because he has just left the meeting to attend another commitment, and guests. Chair, I only have two issues that I want to speak to. The first one, Chair, as per the presentation, is on slide 19, Chair, where there's an amendment of section 1 on the definition of designated employer, which has been revised to limit the application of companies with more or with 50 or more employees. So my question, Chair, around this issue is that, are we not going to find ourselves in a problem whereby those companies who have 50 employees would then try to then cap their employees to 50 in trying to avoid this section as per the amendment, because there's this exemption of the employers who have less than 50 employees. What impact is it going to have if then they try not to increase their human capital to more than 50? Because currently in South Africa, we have a challenge of job losses. What is the balanced approach that you are going to employ to ensure that as much as they are exempted, but there is job creation at the end of the day? The last one, Chair, that I want to speak to is on slide 18. I mean 28. The presenter, Mr. Mkalipi, did indicate that the system, as we speak, is up and running, and the system is automated. And now, Chair, when you listen to the presentation, practically for me, there is going to be a reconfiguration of the system, since he did indicate that it is going to be integrated with CCMA, case management system, and national minimum wage exemption system. Now, what I want to get from that is that we've been experiencing some challenges in our electronic systems. Is this one not going to be prone to manipulation, fraud, and corruption? And what is the state of readiness on our side as the department, as far as capacity building of our employees and functional requirements is concerned? Those are the two issues that I wanted to speak to. Thank you.
Thank you, honorable members. I'm not quite sure. I would assume that I would request that members lower their hands so that I don't become confused. Honorable Ngabane, Honorable Nkondo. We will then allow the department how you respond to these questions of clarity and some comments will depend on you, DG, and your team. Over to you.
Thank you, Chair. I'll ask Mr. Mkhalip to just kickstart our response, Chair. We'll then add.
Thank you, Chair, and thank you, members and DG and Deputy Minister. The first question that is being asked is on the case law. Honorable Kadu is correct. There are other cases, the Barnard case, the Constitutional Court pronounced on the constitutionality of employment equity on the Barnard case. We have not quoted it yet. Therefore, there are other cases that we can quote in terms of the constitutionality of employment equity. And we are confident that this bill, just like employment equity has stand the test of time in terms of constitutional challenge, will stand the test of time. We believe that the targets that we are setting are not quotas. If they were quotas, the law would not have allowed companies to have justifiable reason as a way out if they do not meet the target that has been set. If they were quotas, then they will have to meet them at all costs. Now, the fact that the law allows companies to be able to indicate justifiable reason for not meeting the law indicate that. Therefore, we can't sit here and say we're confident. This is the Constitutional Court, when it's taken on challenge, it's our duty to defend it and show the court why this provision of the law and this bill stand the test of time. And so far, it has. If you look at the Barnard case, employment equity has been confirmed by the court as a correct legislation to redress the barriers of the past. Therefore, the court has not said that the issues that we're looking at to redress are wrong issues. We're looking at wrong issues. Therefore, if there's any other challenge, we can't stop people challenging legislation. We live in a democracy in this country. Anybody has got the right to challenge, and as government, we've got to be able and go out and defend the law as put it. And as we've indicated, we're confident that this legislation will pass the test of time, both in the issue in terms of what it's trying to address, the introduction of the issues around the quota themselves, and the issue of what the effect will be of a company that has not been given a certificate. Obviously, honorable members, there are consequences in any country for not complying with the law. If you as legislators pass a law and the law is not complied with, there are consequences. We hope that companies who are not able to meet their target will be able to indicate that they are not able to meet those targets and they've got justifiable reasons for not doing so. If they can show that, they've got nothing to fear from us. And if that was the case, they wouldn't have an agreement on this issue at NEDLEC with business that were discussion of. Business did not have an issue. And in the companies that we consulting on setting of target, as we've indicated, there's in majority of them already been an understanding. We are closer to an agreement on these issues in terms of setting the target. Therefore, on all those questions, we believe that there's case law that indicate the effectiveness and the constitutionality of employment equity and redressing the imbalance of the past. And I'm challenging members to look at the Barnard case. It was precisely asking these kind of questions. And the reason we quoted this case is because it's Solidarity who came here and raised the same issues that they raised in the case. And it's our responsibility to make sure that members know where they're coming from, what case are they talking about, what has been the decision of the courts in those cases. And that's the reason that we quoted that case. We do not quote Barnard and other cases that support employment equity. On the question raised by Honorable Konto, Honorable Konto, the issue of youth employment, unfortunately, and employment equity can only deal with redressing the imbalances of the past. The issue of employment of youth, we do not get statistics and ask employers because it's not really an employment equity issue in terms of the issue of youth of employment. Therefore, we don't have those statistics that we can say are youth being employed in employment or not. And we wouldn't have a legal provision that allow us to ask those kind of questions. That's why we are not having the statistics about youth. Yes, I agree with the issue that they're raising. The problem of unemployment of youth is very bad in our country. Many youth are unemployed, and we need to do more to ensure that they are able to enter the labor market. On the issue of recruitment, the reason we're putting recruitment, remember, honorable member, that the law and the constitution does not require that a company must employees who are already in the company in order to redress the imbalance of the past. The reason recruitment is an imperative for employment equity is that if a company has got a turnover of 5%, it gives reports to us as a department on an annual basis. We can see on the numbers that we are getting whether there's been people in, people out, and then we look on those people that have come in, we look on the statistics that they give us and say, you had 5% vacancies for the last 12 months, and you've used those 5% to perpetuate underrepresentativity of African female and African male and coloreds and colored females, because you've employed only white males to fill that 50%, that 5% vacancies that you had. And that's why recruitment is important, because it talks to turnover. And if a company, there's no turnover, it's got a zero turnover. Therefore, it means that nobody's leaving this company. They don't retire, they don't get dismissed, they don't resign. Then the chances of that company, unless it grows, the company grows its turnover and employ more, you're not going to be able to affect transformation. And that's why recruitment is put there as one of the reasons, therefore, to enable a company to say, well, we did not have any opportunity to recruit anybody. The company has not grown in the last 12 months. Nobody has been recruited into the company. And the statistics will tell us that if nobody has recruited when they say that. And that's why we've put in recruitment on that. And that's how we look at it in terms of this. Now, on the issue of consultation, honorable member, I'm raising this issue because in the labor market, that's how it's understood. Consultation is not negotiation. Consultation, obviously, in terms of the law, there's case law that indicate that when you consult with good faith in order to reach a settlement. But the law is clear. In consultation, if there is no meeting of minds, we can't then say, if a company says it wants a 0% target, if a sector says, in this sector for the next 5 years, we don't want any target. And therefore, if we can't agree on that zero, the minister can't do anything. We're explaining this so that we can all understand, yes, consultation, you consult in order to, in good faith, to reach an understanding on that. But if there is no meeting of minds of the parties, we can't say, therefore, then the law must not be applicable, because in consultation, we could not reach an agreement on this issue. Just like public hearings. If people raise issues in the public hearings and members of parliament don't agree with the issue, they still have got the responsibility to decide whether the bill or the policy goes through or doesn't. Yes, we can't say, well, we can't do anything because in the consultation that we've had, we could not reach an agreement. That's the only thing that we explain. And these employers understand, the sector understand this concept of consultation, that what consultation is. But that doesn't mean that we consult not in order to reach an agreement in terms of this issue. Now,
sorry, Mr. Mkalib, sorry, Mr. Sakaza, can you please mute?
I'm muting. Sorry, Chair. Did go to a meeting, because I must just leave the meeting.
Mr. Sakaza, can you mute?
Now, Honorable Dana is raising the issue about whether a CSR is proper, it was done in terms of what it should have been done, whether it's got what she wants to be in the CSR. Remember, I indicated what is it that the CSR is asking. There's a template that we need to fill. That templates indicate to us what information that we can give. I cannot answer for cabinet and say cabinet is satisfied with. Cabinet has looked at the CSR and agree. If cabinet was not satisfied, they would have sent it back. Therefore, for us, we following the process that has been put in place for us in terms of what are the issues that we need to answer in terms of these issues. Now, if Honorable Dana believes that the CSR process is, as far as she's concerned, is not proper, it does not give enough information, then she can start the process, maybe engagement with the Department of Monitoring and Evaluation and say, well, rework the template, ask different questions in terms of the templates. But I mean, government is satisfied in terms of the questions that are being asked and the answers who are given. We can only do what is required in terms of that. And we believe the CSR that we've given answer those 4 questions that we've asked to respond on. Remember, I indicated what CSR is intended to do. Honorable Makapane is raising the issue about small companies with less than 50 who are excluded now. Now, this exclusion is not new. Presently, the law does not apply to companies that employ less than 50. It only applies to companies employing less than 50 if their turnover is high. Basically, therefore, what we're doing, we're taking off the requirement of the turnover. It's not a new provision that is in, because companies who employ employment equity apply only to companies who employ more than 50 presently. That's what the law says. And then it says, but if you employ less than 50 and you've got a high turnover, you must report. Now, what has happened over the years is that you have a company that says today that I've got a high turnover, I want a certificate, because they want to tender only. Then we give to them. When that tender is finished or they don't get that tender, they come back the following year and they say our turnover is less. And also how it's becoming very difficult to assess the turnover of a company. You depend on what they give you in terms of the turnover. It's more easy when you look on the issue of number of workers that are employed by the company. We're making it easy for enforcement in terms of this. We do not believe that there would be any abuse in terms of the 50, the threshold that has been set. As we've said, that this is not a new provision. It's already in the law, except presently it's tied to a turnover. Now we're taking away this requirement of a turnover because it's very difficult to monitor and enforce, and it's becoming a little bit cumbersome, and that's the reason that we're taking out. And as we've indicated, we want the economic assessment, impact assessment that we did, tell us that we've got to do more to make sure that small business have got a lesser burden for them to be able to operate. Now, on the question that will this system stand the test of time, they won't be manipulated, the system won't crash. As we've indicated, the system has been operating for quite a long time, and it has not so far done that. But there's no guarantee in any system. And I've said, if you look now, the system in America has been crashed. They couldn't supply their citizens with oil, petrol, because somebody somewhere crashed into their system and crashed into their companies that must be able to provide this, and now they are not able. Therefore, any computer system can be crashed and people can come in and do things. What is important that do we have skills within the department of the government who are able to protect our systems against this? Yes, it's possible. It's protected because the same, if we do not have those skills in the country, I mean, systems that are applicable like SARS that are in, they would also have the same problem in terms of this. Now, in terms of capacity, also the numbers of our inspectors, as we continue saying this thing here, there's no doubt that we need more inspectors, but we've got to try and do with what we've got. Because of the financial situation in the country, there's no chances that we're going to have more inspectors than we have. We have to use what we've got. And that's why it is important that in the enforcement, we do what is possible to ensure that the law is enforced. And normally, companies, if they believe that they are not, the chances of them of being caught not complying with the law are slim, then they won't comply with the law. But if we can make sure that we caught some of the big shots who don't comply with the law and show that the employment equity, if you don't comply, there are consequences, precisely like Honorable Kato raised on the issue. If there are consequences for not complying, companies will comply. If there are no consequences, they are not going to comply in terms of this. Therefore, the numbers must also be balanced with the need to ensure that the numbers that we've got, we use it effectively to ensure that we show that non-compliance has consequences. Thank you, Chair.
Chair, just to add,
Oh, yes, teacher.
thank you, Chair. Just to add to a few things to what Mr. Mkalipi has indicated. There's a question that was asked by Honorable Kato.
Can Mr. Mkalipi please mute?
Sorry, Chair.
There's a question that was asked by Honorable Kato, what will the bill do to economic growth and job creation in the country? There are research studies that have been done all over the world that attest to the importance of diversity and how diversity, if it's leveraged properly, can result in economic growth, and that's precisely the reason why we need this kind of amendment to the bill. That's precisely why we need the amendment bill, because we acknowledging and I'm sure Honorable Calder would agree with us that we are where we are now because of the failure of the what we refer to as self-regulation. Because if there was a genuine and general willingness on the part of the employers to diversify and implement transformation on their own terms, and make sure that there's diversity, the diversity is implemented and applied in their companies, we wouldn't be where we are. Government would not have felt the need to enact a law that forces them to implement affirmative action and transformation in the workplace. So we are where we are because of the labor market failures, especially on the part of the companies who over the years have not even implemented their own employment equity plans. And that's the statistics that Mr. Mkalipi was referring to. And that's the matter that we're trying to correct. So I just wanted to make that point because there is correlation between diversity management and economic growth and job creation, because you are actually leveraging all the skills and competences that you have in the country for the benefit not only of a single company, but for the benefit of the country. Thank you, Chair.
Thank you very much, DG. By looks, we don't have any more hands. I can see that. Okay, Honorable Kado. Honorable Kado.
Thanks, Chair. I'm just trying to unmute myself. Yes, I wanted to follow up on the consultation process around targets. You've undertaken to amend Section 15A3 in light of the public hearings to include consultation with relevant stakeholders, and that's an improvement. But I'm concerned about your response on what happens when there's no consensus, when the minister and the relevant sector can't reach agreement over targets. My question is, does the minister have untrammeled discretion to set targets and to go ahead and make sure they're implemented if there's no consensus between the minister and a sector? And if the minister does have that untrammeled discretion, what are the parameters that guides the minister? Thank you.
I think the department has responded on consultation. And I just want to again repeat, we are going to be engaging on deliberations. And if we think that we have got a different view, we will have to do that then, because now we are then going to be, what is it? I don't want to say forcing the department, but because when we are deliberating, the department is going to be there with its legal advisors. We will also be there with our legal advisors. Members are entitled to raise issues which they think they are not comfortable, if they think that the department has not gone far, and we raise that when we are deliberating, because we're still going to deliberate who agrees, who don't agree on this, why this, we want to add this. Even if something is not in the bill, as we have gone through, we think that, I'm making an example, we think that as the ANC, this must be added here as much as, and we are advised on that. So I'm humbly requesting the department will respond. I'm not going to say it must not respond. The department will respond. That's fine. But I'm just trying to caution honorable members that we must not be tempted to deliberate by default. We are still going to do that. Honorable Dana.
Thank you, Chair. My question is sort of the same, but it is a question of clarity. It is unclear to me what the parameters of the minister's discretion will be with the setting of targets. So I would like to know what the parameters of the minister's discretion would be, or will he just have free discretion to decide as he likes?
How can, okay. No, I see the minister is back. Mr. Mkalipi, before we give the DG and the minister, do you want to come in here? I see your hand, Ms. Minister.
Yeah, yes, Chair and honorable members. There was a question that we missed about the abbreviation on slide number, I think 28, the SAC. It's a mistake. It should be an SARS. It's a SARS certificate. We apologize for that. On the issue of the law is clear. I mean, if you look at the LRA, let's look at the LRA. The LRA indicates that in terms of Section 189, before an employer retrench any employee, there must be consultation. That's what the LR says. And then there has been court decision in this country that unpack what consultation is all about. And the differentiation between consultation and negotiations are made by the court. No law has defined a consultation or negotiation. There's no definition of that. You're not going to find it in the LRA. You're not going to find it in the BCA. You're not going to find it in this legislation, because consultation and negotiations, it depends on the parties. It depends on the nature of the issue that have been consulted. It depends on the time that you take of consultation. What we're stressing is this: in terms of the law, the minister must consult the sector concerned, just like the minister must consult the commission. But when you consult, nowhere in any law does it say in that consultation process you should not, you should take away the right of the principal to make the decision. Obviously, in making that decision, reasonableness is important. If the other party is able to show that in the consultation, the department was unreasonable in not acceding to some of the proposals that have been made on the table, and they have not come up with anything, if they can show that, and those are the parameters that are put in. You never put any parameters around the issues of consultation. Otherwise, you would have put parameters around Section 189 and say employers can never retrench unless there's an agreement. Now we cannot chop and change. When are we happy with consultation? Consultation means exactly that. That's why in retrenchment situation in terms of Section 189, it's not expected that it's negotiation, but parties must consult with an open mind, must consult in good faith in order to reach an agreement. But if that agreement is not reached, you cannot hamstring policy decision so that they cannot be, just like you cannot say a company can never retrench because in the consultation, they do not have an agreement. That's how consultation is understood in the labor market. And that's how we understand it also. Thank you.
Thank you, Mr. Mkalipi. Mr. Honorable Mkondo.
Chair, I really thought that we will be protected from this. I'm the one who raised this question initially. It's not a matter of not understanding the processes of consultation, but my worry was the closing statement. It was intimidative, and to me, it appeared as if all we are doing can just be ignored and nullified and so forth. I even said, I think the statement has been pronounced prematurely because we're still busy with the consultation. So why the statement? Why are we told in the middle of consultation that this consultation might end in this and that and that? To me, the department, if they close their presentation with such a statement, it means they themselves are not consulting in good faith. Thanks, Chair. We understand consultation, but to me, it wasn't for the department to make a closing remark about reminding us as to what will be the results of consultation. Thanks, Chair.
Can I come in and humbly appeal to honorable members? I see your hand, Minister. Can I just come in and appeal to honorable members? Just to take us back, because I must just take one step back to come to where the bone of contention is. We invited, we put as Parliament, as the committee of the National Assembly, an invitation for everybody to comment. And that was about 2 months. We extended it to 2 months and two weeks, and then we closed for submissions. We then again, because there were requests for oral submissions, we allow that to happen as a committee of the National Assembly on Employment and Labor. We are then, on our side, we are done with consultation. There are people that have raised issues with us. We may agree, we may not agree with them, but we have consulted. It does not mean that if company X came in front of us and say ABCD, we are compelled to take that. We're still going to engage. We may agree, we may not agree. So I just wanted ourselves have gone through that process. Now we are not consulting now, honorable members. We are done with the process of consulting. The department is responding on issues that were raised because we must have that so that we also, and it does not mean that when the department is in front of us and has raised ABCD, we are also compelled now to say, "Hi, we will agree on this." We are still going to engage. We may agree, we may not agree with what the department is saying, which then may also change these amendments that they are putting in front of us. That's our responsibility. So I'm humbly requesting members to be patient. We are still going to go into what is called deliberations. And I want to repeat this. There may be clauses or sentences or chapters that we may delete, throw them out of the window. Again, as members of the portfolio committee, in terms of our political affiliation, we may still agree and disagree amongst ourselves. So please, honorable members, let us be patient to one another. I thought it's my responsibility to just guide you so that you don't feel well. If the department will then respond on the statement and how Honorable Mkondo feels, but for me, I think that I must also remind ourselves that we have also been involved in a process of consultation through written submissions, and I hope members will then go back and look into that through written submissions and oral submissions. Again, I want to labor on this. We're not compelled to agree on what has been presented in front of us. Honorable Minister.
Chair, I think there must be an understanding that public policy issues are very complex. And these occur in a rapidly changing and turbulent environments. Those environments, there's a lot of uncertainty, and they involve conflicts amongst the different interest groups, different interests. And I'm raising this issue that you're talking about different interest groups. You're talking about political parties in parliament being or carrying mandates of different interest groups. So that's very important. And ours and the history of South Africa has been that through persuasion and powerful reason, we've been able to reach a consensus on very, very difficult and complex issues. Sometimes you say sufficient consensus, not unanimous. Because if you are not going to be able to move, there is no 100% unanimity, but you do have sufficient consensus. You have to continue. But it's important that when we're talking about different interest groups, they are not a monolith. They are not a monolith, Honorable Mkondo. They are not a monolith in the sense that you might find that amongst labor, as an example, there are differing interests. They would advance differing positions. And in the society where we are, and I dare say it's a liberal democracy, we try and find a consensus, we try and mediate so that we're able to reach a consensus. But if we do not, if we're unable to reach that consensus, we are able to move and take into consideration what has been said, where parties are closer to each other but not agreeing. We do not just act unilaterally. If you look at the different policies we've had, the different legislations which we've had, that's how we have dealt with them. There's never been any unilateral action from the ministry. So I don't think people should worry about that. But also people should acknowledge that apartheid provides for the basis of employment equity, provide for the basis for radical transformation of this country. We're not going to sit and defend apartheid inherited privileges. And when we're talking about socioeconomic impact assessment, that is done to identify and assess the potential economic and social impacts of a particular proposed policy. That is done exactly to deal with those issues. This means a lot of issues where you measure the changes in the job creation, the income, and so on and so on. All I'm trying to say, we do not just move unilaterally in an unscientific way. We must listen to those views, consider those views, even if we have to dismiss them. But at the end of the day, we work on persuasion and powerful reason will rule. That's how we do it. But you will never have 100% consensus. If you have it, good luck. That would be good for us. But if we don't have it, it doesn't mean that we can't be able to move. The fact that the cabinet has released this for comment, the fact that we have received the comments and we are coming back, that's the consensus which we are trying to build. And we are trying to make the parties understand that this is where we're coming from, the angle where we're coming from, as and when we come with a final product. It would have been informed by these various submissions. Thank you, Chairperson.
Thank you, honorable members. We have requested the department to come and respond on all the issues on the employment and equity. Ours now is because this then preparing for the third leg, which is for us to then deliberate. We will then have to do that, taking into account all that has been raised by the department. You know, transformation is quite a very challenging struggle, because if we are going to isolate it, and transformation is quite a challenging struggle, and Parliament is a site of struggle. So I think what we have to understand is that, but in the center of all that is that, what is it that we want for our country? It's not about what I want as Lindelwa Tunjwa, who is a member of the African National Congress, but together with our differences, different views, because that's why we're called politicians. It's a theater of struggle. We engage, because one thing that we can't do, we can't disengage. We engage, we persuade, we become tolerant, to one another. Obviously, within the context of being disciplined. And we will have to be allowed to raise our ideological views. It's how we do it, in my view, which is important. And I do think that, honorable members, we are now beginning to be, because we have that responsibility given to us. There may be some utterances that are making us uncomfortable. We will understand the process of lawmaking is not quite easy. It had some, we'll say some utterances that will make other people uncomfortable, maybe because of not understanding. The department will respond. We may come back on how then the department responded on A, which made us not to be comfortable. They are still going to, when we are deliberating, they are still going, there will be areas guided by their legal team, us also guided by our legal team. So it's really it's challenging but exciting, because we are lawmakers, and therefore we will then have to ensure that we become cool and collected. Yes, there will be days that we may lose our cool a little bit, but we collect ourselves and say, we have got a responsibility of ensure that we come up with a legislation that is going to assist the country. Because it's our country that comes first. Having said that, honorable members, next week we are meeting, but we are likely to be meeting the office minister and members, the office of the Auditor General on the 28th. We're still talking with powers to be on the 28th, which is Friday. We know that it's a joint sitting, but we have, because this is urgent, 2 of our entities have been called, by SCOPA. So we want the AG's office to take us through, and then if then we do get a permission, which I think we're likely to get it, because this is of a national interest. Remember that SCOPA did say in their sitting that the compensation fund, and the minister did raise this in the budget vote, that they had a 10-year disclaimer. That now is it has always been a matter of concern to us, the state of the compensation fund. Same applies with UIF. So I want members to be aware of that we are likely to be having that meeting. I am still engaging and persuading powers to be allowed that we sit even in that morning of the joint sitting, because we can't leave this any further. We are going to go to a recess. Next week is our last week, and we still got to ensure that we apply to sit for deliberations during our constituency, because we can't stop now and say we will deliberate in August. Our minds would have rusted, and we've forgotten what we've asked. So it's important that we do that, because at the end legislation takes precedence. But because this thing is going to happen during constituency, so we'll have to make a formal application. The second one is, which we will deal with it after, Minister, after these two deliberations. Convention 190, I'm told, has been 80 seats. I am also going to communicate with the Office of the House Chair for Committees to say, can we be allowed to finish these deliberations and then request, when we come back in August, request the department to come and brief us on Convention 190. We will request the committee section, my office will request the committee section to circulate the copies to all of us, so that by that time we may have gone through that. I want to apologize for a glitch that happened during the time I was speaking with the committee secretary. Ufuna uthini Zolani?
Andithe ndithi yonke
Can you please mute? Mr. Chakaza, can you please mute? So that has come to the end of our meeting. We will then interact in terms of the possible meeting of the 28th with the Office of the AG. Thank you very much, honorable members, Minister and the TM, DG. Thank you very much. Good morning, Mr. Inana.
Hello, good morning, ma'am.
Our meeting is adjourned.
Thanks, Chair.
Thank you very much, Chair. And the honorable member.
Good morning to everyone. Thank you.
Morning.
Recording stopped.